Okay, thank you. My name is Ralf Bendrath. I'm here for Digitale Gesellschaft, one of the members of European Digital Rights.
Thank you. My name is Estelle Masse. I'm policy analyst at Access, based in Brussels. Access is a digital rights organization that works around the world to defend and extend the digital rights of users.
Hi, my name is Gaelle Krikorian. I used to work as an advisor for the Greens on IP issues, and now I'm starting a new research project on IP issues and free trades.
Hi again, I'm Sanya Reid Smith with Third World Network. We look at the implications of trade agreements on consumers, and I'm based in Geneva.
Okay. Okay. So, this is a follow-up to the previous talk by Sanya. Maybe, can I just ask, who has not been in the previous talk here in this room? Ah, okay, good. So we do some repetition. So you will hear what's the thing about these new trade agreements everybody's talking about, and then especially we will look into 4 areas where these trade agreements might affect the internet. The free, open, private internet, as we all love it. So trade agreements 2.0, what I call them here now. Just quickly, that's developments you probably have heard of: Trans-Pacific Partnership, Trade in Services Agreement, Transatlantic Trade and Investment Partnership, the Canada-European Trade Agreement. And there's also others between the EU and India, between the EU and Singapore, and what have you. The thing with these new trade agreements, a new generation of trade agreements, is that they are not mainly aimed at reducing tariffs, because there are basically not much tariffs left anymore in global trade. They are about regulatory standards and regulatory cooperation. So what they basically do is, in these trade agreements, they negotiate stuff that normally is in the remit of normal, ordinary parliamentary legislation, such as food safety standards, car safety standards, data processing standards maybe, and stuff like that. This is now done on these trade agreement negotiations behind closed doors, and then afterwards the parliaments can only say yes or no. And of course you all have heard about the investor protection clauses, dispute settlement, the private courts, so to speak. And these trade agreements also create a lock-in effect, because once you have adopted them, you basically can't get out of it. There's no way back. So, do you remember how we killed ACTA 3 years ago? That was fun, wasn't it? But things we fought in ACTA, like criminalization of intellectual property violations and so on, it's coming back again, now in the shape of trade agreements. So it's a bit like zombies, and this will be the theme for our talk as well. Here's already a zombie flash mob some activists did in front of the European Parliament to protest against the EU-India free trade agreement 2 years ago. They were actually dancing in front of the Parliament to the Michael Jackson Thriller. That was really fun. So, first chapter, so to speak. How can trade agreements be a threat to data protection? So, how is EU data protection endangered by trade agreements? That's something I work a lot on. So, if you look at the current EU Data Protection Directive from '95, which is at the moment being revised, there will be a new law probably next year, but this is current EU law. Article 25 says the transfer to a third country outside of Europe of personal data may take place only if the third country in question ensures an adequate level of protection. And that's because data protection as a fundamental right is in a way a right that travels with my data. So if my data is transferred to another country, I want to make sure that I still have the same rights, like right to have access to my data, to correct it, to have it deleted and stuff like that. And that's why at the moment there's this kind of pseudo-agreement called Safe Harbor between the EU and the US, where American companies can voluntarily submit themselves to Safe Harbor principles that are, in a way, modeled after EU data protection rules. and then they can receive data from Europe and process it further in the US. That's at the moment being revised because of Snowden. So the United States negotiators put a draft chapter for e-commerce on the table about a year ago for the Trade and Services Agreement. And Article X4 says, no party may prevent, blah, 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 a party from transferring personal information outside the party's territory. This would exactly go against all European rules on only transfer to third countries when there's adequate protection there. This clause, if it would be adopted in TiSA, would even mean that TiSA member states, it's about 30. Sanya, how many? TiSA? 30 something? Yeah. That these countries could even transfer the data to any other country outside of the TiSA membership, so to speak. And you, as a so-called data subject, a person whose data is processed, you would have no clue where the data is and would have no control over it anymore. Then there's exceptions from this free flow of data. There's already, in current World Trade Organization rules, in the General Agreement on Trade and Services, there's an exception, Article 14, that says you basically can keep your privacy laws if they are necessary, and this is not considered a violation of trade. There's some limitation to this, and Sanya already said in the previous talk that it's difficult to enforce these exceptions, but at least there is one, and the EU negotiation mandate for TTIP also includes, the mandate for the European Commission, for the negotiators, includes that this exception should stay in, also in TTIP. And that's basically what everybody in Europe agrees on. In my main job, I work in the European Parliament for a Green member who's also one of the rapporteurs on TTIP, on the data aspects. So if you talk to the Commission, to member states, to even European industry, and of course NGOs, they all tell you, yeah, we want to keep this exception or even make it stronger. On the US side, it's a bit more difficult. The Americans are currently discussing their fast-track procedure for trade agreements, including TTIP and TPP and others. And there, the chapter on e-commerce says, where legitimate policy objectives require domestic regulations, blah, 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 to obtain commitments that any such regulations are the least restrictive on trade. So you could theoretically still keep a privacy exception and do domestic or inner European privacy regulation and laws, but only if it's a legitimate policy objective. So what does legitimate mean? In the trade environment, I was told from people who are more familiar with trade agreements, it basically means legitimate is what everybody is doing already. And this is not the case for data protection, because it's basically a European invention, and some countries have copied it, but it's not spread all across the world yet. And then the other point, of course, what is least restrictive? That can mean that the Americans will demand from Europe that we only do very, very lightweight data protection laws, no strong obligations for data controllers, and so on. And then it actually, I just discussed it recently with one of the people in the European Commission who are negotiating on this. They also say this is not even a real exception, the way it is worded. So that's what the US is putting on the table, pretty weak, not by far not enough for European data protection standards. And then the Americans have another issue with so-called data localization, which they want to prohibit. That would mean that data processing has to be in a certain country. And also the equipment and everything has to be there. So they're now pointing at Russia. Russia just introduced a law or adopted a law that requires local data processing. Similar things are going on in China and so on. So the Americans are now pointing at Europe. This is like what the Chinese and the Russians are doing, data protectionism and so on. But as I said, under European data protection law, this is already the case since '95. If personal data is processed, it has to be in Europe by default, and it can only be transferred to other countries if they have an adequate level of protection. And by the way, there's also one paragraph in the European Court of Justice ruling on data retention from last year, April, where even the European Court said the Data Retention Directive, which they killed with this ruling, that directive didn't have any provisions that ensured that the data stayed in Europe. So even the court said that you might want to do data localization, so to speak. And the fun thing is, even the US has data localization provisions. So the General Service Administration, that's part of the US executive branch that provides like services for the different departments and so on. They are working with blanket purchase agreements for cloud service procurement. So they have like a general blanket agreement with a big cloud provider, so maybe, and then other public authorities can just say, okay, I'm going to use that big agreement for purchasing my cloud services. And these services acquired under this BPA must reside in continental US territory. So they do it themselves. Okay, fourth question, what about the NSA? In the US draft for the e-commerce chapter of TiSA, Article X7 has a national security exception. That's quite interesting. Nothing in this chapter shall be construed to prevent any party from taking any action which it considers necessary for the protection of its own national security interest. In a way, it can be read both ways. You can say, okay, this would be the big loophole that still allows the Americans to spy on everybody and do whatever they want if they just consider it necessary. It doesn't have to be objectively necessary, they just have to consider this. On the other hand, you could also say this could maybe even allow the Europeans to still maintain strong data protection laws and so on, because this is maybe part of what we think is in our national security interest, because we consider it as part of our security. So in a way it can be read both ways, but the European Commission is not really convinced of this text. And actually, when you ask around a bit, you hear that not even the US trade representative is really convinced of this text, and apparently they're now behind the scenes negotiating with the NSA. So the USTR is negotiating with the NSA to maybe have a different wording on this one here. It's a bit odd that they get their negotiation mandate from the NSA and not from the White House or the Congress. So on data protection, you can basically sum it up with if the Americans get what they want in these trade deals, they would basically ban all European attempts to protect us against mass surveillance as a trade barrier. Okay, next is Estelle.
Thank you. As the second chapter, let's say, of this talk, I will talk to you about net neutrality and how trade agreement can represent a threat for this principle. But before that, in order to understand the threat that this trade can pose to net neutrality, let's go back to the basic a little bit and define what's net neutrality. That's the principle that makes the internet what it is and the platform we all use today and enjoy for our daily activities. And that's also the principles that say that you cannot make any discrimination on the network, which mean on the very specific principle, no blocking of throttling or content, and also no price discrimination, no pay prioritization, and no zero rating. The last three exceptions are fairly recent in the market, because for many, many years what we've seen was telecommunication providers blocking content when this could represent a loss for their activities. For instance, for a long time in Europe and in other part of the world, you've seen telcos blocking applications like Skype because they realized people were using Skype instead of making phone calls. So they claimed that it was resulting in a loss for them. So they were intervening in the network to block or throttle the application that the user could not use anymore. This faced a lot of outcry, and it's banned in most of the country right now, and the telcos have understood that it's a no-go for users and are doing it all the time less and less. But the new development we see in the market is this positive discrimination, let's say, where instead of blocking a content, they actually prioritize another content, which is, for example, the deal that we all hear about in the US with Netflix, during a long time Comcast was throttling the level of Netflix, which led to a lot of users complaining to Netflix that they couldn't use the service because the delivery was just not happening, which forced Netflix to actually pay Comcast in order to ensure that the content could actually be delivered and users could actually experience all of the Netflix products. That's something that it's developing as well in Europe at the moment and also in developing countries, and where we see also a new types of product called zero rating, which is the big controversial issue on net neutrality at the moment, where products in platforms on the internet offer their content outside of your data caps. So let's say per month you have 2 gigs of data cap that you can use, but also your telco will offer you Facebook or Spotify outside of those data caps. So you can use this platform for free, let's say. But this is an infringement to the principle of net neutrality, because if you put the user in a situation where, well, either you pay to use all of this platform, but you can use all of this one for free, you actually put them in a situation where they're going to use those, even though that's not the one they are choosing. It's just the telco making the choice for you which platform the people are going to use on the internet. So far around the world, there have been a lot of development on net neutrality legislation. This is a map that shows the country that has either hard law or soft law to introduce net neutrality protection. And the 2 big dots represent the US and the EU, which are at the moment developing net neutrality legislation. The EU through the FCC intervention, and the US, sorry, and the EU through the telecom single market regulation, which is at the moment in negotiation between the 3 institutions, the Parliament, the Council, and the Commission. And we're in the situation where only the Parliament has a proposal which is actually real net neutrality. So this map is only an indication of the law that exists. Unfortunately, in many countries, this law is badly enforced, which means that in the facts, in the bill, you could get net neutrality, but in practice, it's not implemented. So it's not at all an evaluation of the quality of this legislation. It's just to reflect the country that has taken step to introduce protection for net neutrality. Most of them are focused only on banning blocking and throttling, which was the historical discrimination that we see, but more and more countries, such as the Netherlands and Brazil is looking into it right now. Chile are also developing banning on the positive discrimination we've seen before, like zero rating. So now, how could TTIP and TiSA undermine net neutrality? In the TiSA leak on e-commerce, if we have a look at the proposal, and if you're lucky enough to have a look at the version with the bracket, you could see that the proposal is made by the US, but also supported by a lot of countries, such as Canada, Australia, Chile, Colombia, Israel, and Japan, Norway, and Peru. They introduced this text on net neutrality, which says that that users can access and use service and application of their choice available on the internet, subject to reasonable network management. So now, this sentence, in a context where there is no zero rating, could be okay. There is a lack of definition. We don't really know what they mean with reasonable network management. This is an important point. So we would need further definition, but that would be maybe an acceptable basis to start working on this issue. Now, we're not anymore in that context. We're in a context with a lot of zero rating discrimination, and having a text saying that users can use and access application of their choice available on the internet might actually be a loophole to authorize telco to chop the internet into pieces and to deliver access to only specific services that they choose for you. This is, for example, what a project like by Facebook is doing called internet.org, which gives you access to only 20 services chosen by Facebook that are available over the internet but are not the internet. But that proposal might not ban this kind of project that are an infringement to net neutrality. In addition to the text that we've just seen, there is Japan is going a little bit further than the other, and is also introducing a text that is extremely vague and undefined that will pose a lot of problem, where they talk about unreasonable discrimination and lawful network traffic. So it's also to see that the US text is really bad, but the US is not the only one here proposing provisions that are concerning, and we need to have a look at everything that's going on in the TiSA, because this is really big, and the TiSA text, by the way, is also the same as the one proposed in TTIP. So the US is proposing the same text both in TiSA and in TTIP. The only thing is, like in TiSA, he gets the support or other member of the agreement. So in general, about this leak, we see that there is this lack of clear definition of when we talk about the network, and there is the issue of no banning the price discrimination and zero rating schemes. If you remember the map that we've shown just before of the country where you have net neutrality protection, well, now you see all the country that has a red dot are member of the TiSA agreement. So potentially, if the text of TiSA stays like that and authorize zero rating practices, and if the agreement enter into place, all the countries with the red dot might lose their protection over net neutrality, leaving only Ecuador and Brazil with net neutrality protection. It's interesting to see in this text that many countries that are actually supporting the text from the US, as we see in the map, also does have net neutrality protection. So here, two things are possible. First, the text has been proposed a little bit over a year ago or 2 years ago, I think. And it's true that zero rating at that time was not a development of the market. So some country might have generally put this text because it reflects what had their legislation, which was focused really on blocking and throttling. Now, it's interesting to see that they still support that text. So there is an urgent need for them to reassess the text right now. If not, the trade agreement might overrule their own legislation and they will lose the protection that they promise all of their citizens around the world. So as a summary on net neutrality, there is a possibility in trade agreement that net neutrality protection will be overruled, which is really scary because at the moment we are in such a big battle in both sides of the Atlantic, the US and the EU and all over the world to get net neutrality protection, but at the same time in those trade agreements where we have very little access, governments are actually trying to overrule this protection and do all the work we're doing at national level. So people really need to understand that the TiSA agreement is really important on that point because there is a lot of protest around TTIP, which has a lot of very bad provision, but everything which is in TTIP is in TiSA. And it's really interesting to see when we talk with our counterparts in the US that there is very little interest about the TTIP at the moment. It's mostly because they're finalizing the negotiation on TPP. But when you talk to them, they say like, oh, it's funny that in Europe you look at TTIP. Our next biggest issue is TiSA. That's where we're going to get what we want. So people need to start also worry about TiSA. And now the third part.
Thank you. So third part is going to be about intellectual property provisions, and we are going to see how it can hurt the internet and its users. The zombie thing, so FTAs, free trade agreements or trade agreements always come back with the bad provision, and that's particularly true with intellectual property issues, provisions that we find in the intellectual property chapter. So in each of these agreements there is one chapter dedicated to intellectual property. Under that, you know, intellectual property, that covers a lot, so it's a lot of copyright issues, trademark, patent issues, geographical indication, plant breeders, etc., etc. These intellectual property chapters are being used primarily in the past by the US and now by the US and the EU to increase the protection of intellectual property and to go above the international standards. We have the standard from the World Trade Organization that all members have to follow. That's the TRIPS agreement. These FTA are used to go beyond that. We will see in this presentation, I will give you a couple of examples. So one of the problems we have is not only the intellectual property provision in themselves, but how they can be used in that mechanism that you may have heard about, ISDS. So ISDS, oh, the GIFT is working, okay. So what is ISDS? ISDS is a mechanism that allows foreign company to go after government when they consider that their investment are jeopardized. They consider that there is expropriation. And the funny thing is that, you know, the way those two terms, investment and expropriation, are interpreted is pretty broad. So investment covers intellectual property, and expropriation means that the investment has lost some value. The value of the investment has been reduced. But the investment can be what the company was planning to gain, benefit that were planned, so not even concrete, you know, actual things that she possessed. So this ISDS mechanism is now in a lot of FTA, free trade agreements. And we see the number, I mean, we see both the number of ISDS clause in FTAs and the number of actual case growing very quickly in the past few last years. There is a big discussion now going on about whether this mechanism should be part of TTIP. We probably heard about it. One of the cases that we usually use to you know, show how it works with intellectual property issues is this case in Canada with the company Eli Lilly, who went after the Canadian government because the Canadian government decided not to grant 2 of the patents that the company was asking, because, you know, it's up to government to grant patents, and they do it using what we call patentability criteria. So after examination, Canadian courts considered that, you know, it was not the 2 patents were not legitimate, and they decided not to grant them. The company considered that was expropriation. They went after the government. The case is still going on, and what they are asking for is $500 million. So this gives you, you know, an idea of the scale of the damages that the company are asking for. What's going on now in the EU is, so like I said, there's been a lot of discussion over this ISDS mechanism and whether or not it should be in TTIP. The Commission has been obliged, the European Commission has been obliged to run a consultation. Dozens of thousands of people responded to this consultation. And now the Commission is coming back with a proposal. There was an announcement made yesterday by the Commissioner Malmström, who was talking at the European Parliament. Today she's talking with the EU Council about their proposal. The political statement from the Commissioner are positive because she's raising the problems that a lot of people have been raising. The concrete proposal that the EU is making at this stage is not very convincing, and there is a lot of loopholes and uncertainties that do not really make us feel very safe. So this is still a battle to go on. Now, third aspect I wanted to talk to you about is trade secrets. So trade secrets, it's a new issue that we are now being confronted to. What is it? It's specific provision for information that is not protected by regular intellectual property titles. So it's not going to be protected by copyright, and it's not going to be protected by patents. Why? You know, because, you know, it doesn't deserve protection. You know, it's not an invention, it's not inventive enough to deserve that type of protection, for instance. However, you know, through trade secret protection, it can be protected. So it's going to be something that is secret, something that has a commercial value as being secret, and something for which the owner has made reasonable efforts to keep it secret. The problem with that is that, you know, it can be many, many things. It can be, you know, it's the famous example is the Coca-Cola formula. It can be a design, it can be an ID, it can be a list of clients, it can be, you know, a LinkedIn account, it can be many, many things. And that's where we are starting to worry a little. Because now the idea, and that's the risk we're facing, is that this is going to be negotiated in the context of TTIP. So as I said when I was presenting myself, until recently I was working with the Green, and at the European Parliament, that's a campaign we launched to try to raise people's awareness. The problem with trade secrets is that it's going to be used by companies to refuse to disclaim information about, whatever chemicals they send back in the nature. It's going to be used to refuse to communicate information about medicine, result of clinical trials, side effects. It's going to be used to prevent employees to be able to move to other jobs using the fact that some of their skills they acquired during their past jobs, and if they now go to somebody else with those skills, they're going to transfer some trade secrets. And it's also going to be used to go against and to prevent whistleblowers by saying that they cannot reveal information because it's bringing them to reveal some trade secrets. We've seen it with LuxLeaks recently, and that's one of the arguments the court in Luxembourg is using. So our problem now is TTIP, and because of TTIP, there is a lot of pressure to have an EU directive, because the situation now with trade secrets in Europe is that every country has its own way to protect it. For some, it's intellectual property, but most of the EU countries, that is 26 of the EU countries, do not consider that trade secret is intellectual property. They protect it through different ways. It can be an issue of anti-competition, it can be, in the context of labor law, in many different contexts. But TTIP is coming, so now we are at the level of the European Commission. We have a draft proposal for an EU directive, and it's being discussed at the Parliament. It's been presented both by the EU negotiator and by the US negotiator as a priority for them in the context of TTIP. It's already in the draft. We don't have a text, but it's listed as one of the topics in the intellectual property chapter, which is a big problem for us, for Europeans, because, like I said, for most European countries, it is not an intellectual property issue. That can sound like a, kind of a detail, but in fact, it's not. And why is it not? Because if you put it in the intellectual property chapter, then some information being made public because, I don't know, the agency, the health agency of some country decided that they should reveal information about some drugs, for instance, because, it's in order to protect public interest. Well, the company that owns the information can say, this is my trade secrets, and if you do that, then I'm going to trigger the ISDS mechanism, and I'm going to go against you, and I'm going to require, €500 million euros as damages. So that's one of the big problems we could have with that. In addition to the fact that, of course, trade secret is going to be used to go against a lot of laws that are made to try to protect public interest and to allow access to data and access to information for consumers. Sorry. So, but one question we can, ask is why in the first place should intellectual property be part of this TTIP chapter? Government may respond, well, because we always have an intellectual property chapter in FTAs, okay? But, when you think about it, the reality in Europe and in EU, and when we talk about the internet, we're mostly interested in copyrights. The reality of the law is that we have different legal framework on both sides of the Atlantic. So trying to agree on something together. Usually the EU is going to put pressure on developing countries to force them to adopt their standards, and the EU is going to do the same, but they're always the big guy in the fight, so they impose things to others, not to themselves. But when the EU and the US are going to negotiate together, they have very different standards, well, you know, nobody is going to be ready to give up on the way they do things. You know, if we have our special way to consider, you know, authors' rights that is different from copyrights, well, the US is not going to change their way and adopt the, you know, the French or the German way. That's not going to work like that. So it's going to be a mess. It's going to be, it can be very bloody between the two. We as consumers know that we may lose a lot of freedom and rights if they agree on something. So what we hope and what we are saying is that they should just not go there, because they're also going to lose a lot of time, fights, have a tough fights together, and that may also, you know, create problems for, I mean, if they want to sign that TTIP agreement, which, you know, is their objective. I'm not saying that I'm supporting that, but if they want to do that, then maybe they should just forget about the intellectual property. The other reason to forget about it is also because now we are coming to the point in Europe, but also in the US, where we're talking very seriously about reforming copyright and trying to adapt copyright to the, you know, the actual reality of digital technology and changes in our societies. How can we, you know, at the same time being in this very difficult process and long process, you know, of trying to find new rules, new balance in this, you know, very complex legal framework, and at the same time try to agree together, I mean, the EU and the US on some standards. I don't think it's going to work. So the best for us, Europeans now, is to have the conversation we need to have in Europe on copyright, work on our reform, and not be rushed because there is TTIP, and not be forced to accept anything because, you know, this is what the US would like us to do. Just to finish, I want to have a quick look at CETA. So that's the agreement that was concluded last year between Europe and Canada. It's interesting to look at it because, you know, like TPP, the Trans-Pacific Partnership, is what the US is negotiating with a lot of other countries. And it's interesting because you could looking at this, you see what the US came with, you know, when they started the negotiation. CETA is interesting because you see what it is that the European Commission came with when they came at the negotiation. And you can see that they came with a lot of very bad demands. So of course, life plus 20 years for copyright protection, because it's now the standard in the EU, but was not in Canada. And then, you know, a lot of so private enforcement by ISP and ISP liability, criminal sanction for infringement, new rights for broadcaster, strong enforcement measure, and a lot of things to try to prevent circumvention of DRMs and technical protection measures. So that's what the US came with, you know, when they started the negotiation with Canada, and that's what was in the negotiation until 2012. It was all taken from ACTA. That was, you know, not very surprising because people also get lazy. You know, they had prepared this text for ACTA. It was rejected at the European Parliament, but, you know, they had this text they were very happy with, so they try to just put it wherever they can. So they try to put it in the Canadian agreement. Luckily, they had to give up on most of that, so at the end of the day, what's in CETA about copyright is pretty okay. There is no big problem. We have some problem on patent, but not so much on copyright. And it is, I think it's because first Canada, you know, fought back, and also because, you know, they knew that, you know, they just had this very big mess with ACTA, political mess, so they didn't want, you know, they could see that people were ready to react, and they didn't want to go there again. But I think we have to be prepared. We cannot trust them. You know, the reason why they rejected ACTA is not because they agreed that all those provisions were bad. It's just because, you know, they saw that the people were unhappy and that it was not going to fly. So looking at those texts and those provisions, I mean, we have to keep that in mind, and keep in mind that they are probably trying to push that in TTIP or elsewhere if they see that they may have a chance do it. The other bad thing that we have in CETA is the ISDS mechanism that covers intellectual property. And so far, we are now in this very strange situation where the Commission already agreed to have this in the in the FTA with Canada, when because then there was a big mess about ISDS, we don't have an EU position on what should be in free trade agreements on ISDS. So, here again, it's going arm wrestling, and we will see what happens. But it depends a lot of social mobilization, clearly. And I will now pass the mic to Sanya.
Thank you. I'm the last person in the relay team. So we've been hearing about ISDS, and just before I go on to how some of these trade agreements are worse than ACTA, I wanted to add a little bit about the general context of ISDS. And of course, this will not be in TiSA, so they say. It is in the leaked Trans-Pacific Partnership Agreement investment chapter, which does not include Europe. It is very controversial in TTIP, with the EU and the US, as has been explained. It tends to be in free trade agreements that include developed countries, and it's also often in, well, almost always in bilateral investment treaties. There are about 3,000 of these now, so most countries have them, and they're still negotiating them. Most countries are still negotiating them. So CETA, the Canada-EU trade agreement, did have a few safeguards for this investor-to-state dispute settlement, but there was still problems. The question is whether Europe can get these safeguards in TTIP, if it negotiates ISDS in TTIP, because the US has a very strong model of what kind of investor protection they want. They have a very strong template for ISDS, and you can see that because when you look at the difference between their model investment treaty and the leaked TPP investment chapter, there's almost no change. 11 countries, including the size of Japan and Canada, could not succeed in making substantive changes to add the kind of CETA safeguards into a free trade agreement with the US. So your chances of getting them in TTIP, not great, even the CETA level of safeguards to ISDS. So what does the US model include that you could be expected to agree to in TTIP? So although you heard from Gaelle that Eli Lilly is claiming $500 million for revocation of 2 patents, that's not actually very high by the standards of some of these awards. So last year, one government lost in ISDS, and the International Tribunal ordered them to pay $50 billion. They have 180 days to find the money. So there is no maximum amount that these international courts can order your governments to pay under ISDS in the US model. The US model also allows the International Court to award compound interest. So the government has to pay interest on the interest, compounded every month, not every year. From the date the government took the action, like revoked a patent, used a copyright exception 5 years ago, until the date you pay, at commercial interest rates, not government borrowing rates. So the interest alone can be $500 million. And who decides how much you have to pay? It's an international tribunal, often at the World Bank. The investor, the intellectual property rights owner, gets to choose which tribunal they want to go to, and the governments, say the European Union, has automatically consented to be sued. So the investor can choose the World Bank Tribunal, which is famous for having insufficient conflict of interest rules. There are 2 cases that we know about, and there may be more that are secret, where one of the 3 judges was on the board of directors of the biggest shareholder of the investor suing in that case. She was connected to the person suing in that case. She did not disclose this. She did not withdraw. The investor won. And the government found out about this conflict of interest, and they appealed. And they said, please, come on, how can this be? And on appeal, the World Bank Investment Tribunal said, the poor investor, the case has gone on so long, we trust the judge to do the right thing, the investor still wins. The same judge went on to do the same thing in another case, also A-OK, no problem. And in the US model, like the Trans-Pacific Partnership Agreement, there are no additional conflict of interest rules. All 12 governments are completely happy if all 3 judges are in the pay and employees of the investor. That is no problem, according to them. So, not surprisingly, under this international tribunal system, a Canadian law professor who looked at the statistics of all the publicly available ISDS cases to 2010 found that US investors had a 98% chance of a broad interpretation of their rights. And when governments win, they still have to pay their own legal fees, which can be $50 million, twice as often as the investors. The law firms are also in on it. They do ambulance chasing, we call it, where they go to the patent owner or the copyright owner and say, did you know your rights have been violated? Let us sue for you. Don't pay us any money. If you win, pay us 10%. So then sometimes when the investor tries to settle to preserve their relationship with the government so they can continue operating there, they might say, we settle for $5 million. Their own lawyers, the law firm, then sues their clients for settling for too little because they were getting a cut. They say, you should have settled for 10 million. So it becomes a very perverse system. So you can see that this ISDS can really mess up the operation of your intellectual property system, as we're already seeing with Eli Lilly suing Canada for its cancellation of patents. So sorry about that little sidetrack. Now we go to ACTA. Ta-da, it comes back. But how is it coming back? It's only in some trade agreements. So for example, we think it will not be in TiSA because that's a services agreement, nothing to do with intellectual property. So if we're talking about the intellectual property parts of ACTA, it has to come back through a trade agreement that has intellectual property provisions. So the concern is, if you're worried about ACTA, some of these trade agreements are what we call ACTA plus, stronger than ACTA, worse than ACTA. How is this the case? Well, even if these trade agreements copied ACTA word for word, the same rules, they are 4 times worse because they are 4 times more enforceable. The first reason is there is no ACTA in force. You guys successfully stopped it. It doesn't operate in the world today. But these trade agreements do come into force and then they can start to be enforced. How can they be enforced? Well, if ACTA had actually succeeded and passed all the parliaments and was operating today, and the European Union didn't comply with ACTA, nothing would happen. No slap on the wrist, no suing, no money paid, nothing. There's no enforcement mechanism in ACTA. But if it's in one of these free trade agreements, one of the other governments, the US government, could sue you at an international tribunal. You would lose because you violated. There would be tariffs, taxes, raised on French cheese exports or whatever, until you change your law to comply with ACTA. So that's one way it's more enforceable, or the second way actually. The third way is what we call non-violation complaints. Even if the European Union complied with all the rules of ACTA, copied into TTIP, the US could still sue you and win because you have nullified or impaired a benefit that the US reasonably expected to get over and above the actual rules. So the ACTA rules go up to here. Then the US has an extra layer of benefits that they reasonably expected to get. Has to be objective, a reasonable. But you don't know what that is. Does it mean you don't issue a compulsory license? Does it mean you don't use copyright exceptions? If you impair it even at all, they can successfully sue you, tariffs on your exports till you change your law to comply. This has been so controversial at the World Trade Organization that it has never applied to the intellectual property rules. Moratorium on it since the WTO started. But it is in all US free trade agreements for intellectual property except Korea. Korea was smart and said, for as long as there is a moratorium at the WTO, we want a moratorium on this non-violation in their US free trade agreement. Will TTIP have it or not? Will the EU ask for a moratorium? The fourth way that it's more enforceable than ACTA is investor-to-state dispute settlement, which you just heard about. So even if TTIP exactly copies the ACTA rules, it will be 4 times more enforceable. The governments can sue you, tariffs on your exports till you comply. Even when you comply with the agreement, they can still sue you and win. And the IP owners can sue you at that dodgy tribunal for unlimited money and compound interest. And they tend to sue more often than the governments, because governments also want to have flexibilities and exceptions to IP and so on. So that's the enforceability. But of course, ACTA, these rules also go beyond ACTA in terms of substance. So in the breadth and the strength of the intellectual property protection, say in the Trans-Pacific Partnership Agreement. Because ACTA was only about how you enforce whatever intellectual property rights you have. If you have copyright of 50 years, how do you enforce it? It didn't force you to go to 70 years. But in the US treaties, it's longer copyright. 50 goes to 70, 95, 120 years, longer patents. For farmers, you have to sign a treaty that makes seeds more expensive for longer, and more of them are more expensive. That will be a problem for 7 EU countries if it's in TTIP. And of course, the US in these other agreements, maybe TTIP, certainly in the TPP, tries to export its own intellectual property rules, for example, on internet service provider liability. You know the Digital Millennium Copyright Act in the US, which has the notice and takedown system, where famously, for example, an economics lecturer put up a podcast of his economics lecture. His surname was the same as a famous singer. And in the US, they have software bots that crawl the web looking for pirated versions of these songs. So it had MP3 and the surname. The bot thought, okay, it must be a pirated version of the song, automatically sent a notice, electronically signed automatically, to the internet service provider saying, take down this infringing copy of my singer's song. Nobody listened to it and heard that it was an economics lecture. The ISP took it down, the economics lecturer found out, he had to send a notice back and say, put it back up. By then the exam was over and the students didn't have the podcast. And this has been used to take down your opponent's material in an election, doesn't go back up until the election is over. It's been used to take down opposing businesses, your rival hotel, take down their website because, you know, copyright infringing mine. It was actually a driving school. They had the same list of suburbs that they served, copyright infringement, an alphabetical list of suburbs, take down your competitor's driving school website. And this is hugely burdensome for ISPs. They get lots and lots of requests. So, even if you just look at enforcement for ACTA, there, for example, the US goes beyond as well. So you can see in the Trans-Pacific Partnership Agreement, in ACTA, there was criminal penalties. You go to jail for violating copyright, but only if there was actual commercial advantage. You were making money. You were selling pirated DVDs in the street. But in the TPP, it's proposed that you go to jail for violating copyright, even without economic gain, no commercial gain. So some say this is file sharing. Go to jail for file sharing. So even on enforcement, the US proposals go beyond ACTA. And so you can see there for yourself the comparisons of TPP and ACTA. Thanks.
So you have seen the zombies are coming back through all kinds of trade agreements. The question, of course, is how do we fight them? It might be a bit difficult because, as you can see, the zombies are bigger than the nice pea shooters or other plants. They also have maybe more resources if you look at all the industry interest and lobbying behind this. But we might be more than the zombies, as you can also see on this nice battleground. So let the battle begin. Thank you.
So we have about, oh, is this on? Okay, yeah, great. If we have about 10 minutes for questions, who wants to start? Yes, great, here we go.
Yes, we heard yesterday from yourself about net neutrality and the campaign Save the Internet. And it sounds like it's a kind of positive way to mobilize people, because if you're just warning people about things that are happening behind the scenes, high-level, complex legal issues, it's really hard, I think, to make a grassroots mobilization campaign. So I think a good way is to have this kind of positive slogans like "Save the Internet," or how do you create these movements about these issues where we don't even know half of it? You know more than everyone, but it's hard to get people behind a campaign that is about something we're not sure about yet, which might become an issue in the future in 10 years. And how do we make some mobilization now, you think?
Sure, thanks. On the net neutrality specifically, it's true that at the moment it's really focused on the EU. Access is also part of the Save the Internet campaign and has proved to be really successful in the previous edition, let's say the first one with the Parliament, and since we've launched it. And I think a similar approach could be adopted for trade agreement as well. We see a lot of protests and organization around TTIP, which forced the Commission and forced the institution in the EU to pay attention to what citizens are saying. So it's true that there is a lot of complexity in trade agreement usually are hard for people to engage to, because even people that are working in those bubbles sometimes don't know what's going on because there is no access to document. We don't know what's being proposed. It takes 2, 4, 5 years to being negotiated. It's changing all the times. So it's really hard. But we see with TTIP at the moment, and we've seen with ACTA, that it's actually possible to do something and to engage on those issues. Now, the dangerous thing at the moment is ACTA was an agreement being negotiated alone at that time, and the mobilization focused on that one. But now we have like 4 trade agreements at the same time, and even more that we're not dealing with in this presentation with EU Singapore, EU India, and there is like other coming up all the time. So the danger is focusing the attention on one, and forgetting about the others, thinking that we will have a great victory, which is true, it will be a victory if there is no bad provision in one of the trade agreement, but if meanwhile we're focusing on one, the negotiators are putting back all the dangerous stuff in another one, then it will have been in vain. So we need to make sure that it's a campaign about all the provision and all the trades agreement. It's important to work on TTIP, but it's important also to have a overall look, because also what we've seen with CETA, it's true that ISDS was not controversial at all within CETA, and a lot of US companies have actually a sister company in Canada. So even if ISDS is out in TTIP, if it's in CETA, they will find a way to sue Europe through that. So the campaign needs to be broadened to all trade agreement, and platforms such as Save the Internet are really helpful for people to engage. And it's really a complex issue, but that's the role also of civil society and other actors to decode a little bit what's going on and make awareness for people, and create tools for people to take action and raise their voice on those issues.
Any other? Okay.
Meanwhile, if I can add something, I mean, you're right, the problem we have is that it's usually very technical issues and it's not easy to access the information. But what we see is also that we have a very good, I think, network and coverage in Europe of activist groups and NGOs who, you know, they're usually not necessarily big entities, but they work very hard, they're very good, they know how to get the information, enough information to be aware when there is a problem, and they know how to, you know, analyze what's going on and you know, and raise the flag when there are problems. So I think for an EU citizen who want to engage, it's not so complicated to identify, you know, through the internet, who is saying what, who has some information. You can always in your network find some people who have the information, or raise a question and you will get the I think you will get the response. The problem we have is that those groups, they are not so big, so it's very difficult for them to do both at the same time, to be doing, you know, the very in-depth analysis so that we can understand what's going on, and at the same time to raise awareness and, you know, wake up citizens saying, please come and say something, because, you know, it really depends on you at the end of the day. So I think we need, you know, each of us as citizens to be kind of like proactive and look for the information and try to see how we can engage. We know there are all those stuff on the table now. We don't necessarily know, you know, what's going to be the first bigger problem in the 6 months, but, you know, for the few coming years, there is all that on the table and we have to deal with it. So,
I have a question about the TTIP and the General Data Protection Regulation. What will be the relationship between the two? Will one be revised to reflect the other? Which will take precedent? And what do you think the likely outcome will be with regards to protection of personal data?
So, as I said, the EU is currently revising its data protection laws. This General Data Protection Regulation is in the making. Maybe will be finished by the end of this year or a bit later. Then there are some people who say it was actually in the draft statement of the European Parliament, the Trade Committee, that's working on a resolution on TTIP at the moment. The draft said we shouldn't negotiate any data protection provisions in TTIP before we haven't finished the European data protection reform, which in a way sounds reasonable, but in reality it's bullshit, because the European data protection law is just normal secondary law, normal EU law, so to speak. But an international agreement that is ratified as an international treaty is above secondary EU law. So it actually breaks normal EU law. So you could do the best EU data protection reform you wanted, and then agree on TTIP, which has some nasty data protection provisions in that the US insisted on, and our whole nice European reform is gone. So that's why actually, as I said, everybody, including the member states, the European Commission and the Parliament, is trying to keep data protection out of TTIP and just have this exception clause in. But it's going to be a fight. I mean, the Americans want the opposite.
And I can add, the way it would work in practice is if you pass a good data protection law and then TTIP requires cross-border data transfers without the privacy exceptions that are required by your data protection law, then the US government, we expect, can sue the EU government at an international tribunal. The EU would lose because the data protection directive would violate TTIP, and the US could raise the tariffs, the taxes, on any EU exports, cheese, German cars, whatever, until the EU changes its data protection directive to comply with the TTIP requirements, which may be cross-border data transfers with insufficient privacy exceptions. So in practice, the EU and US are some of the biggest countries who can withstand that kind of pressure. I think famously the EU wants to keep out beef hormones, so the US is currently penalising French cheese with 100% tariffs for the last few years because the EU refuses to change its laws on beef hormones or GMOs or something. But it's very expensive, and the EU exporters really put pressure on the EU, whatever, Commission and Parliament to change the law to comply because they are losing export markets when the tariffs go up. And they will keep losing them until the law is changed. So if the EU can withstand the pressure, then it can just keep violating. But most of the time, the EU complies with these kinds of decisions. It's very rare that they put up with the high tariffs to protect an existing law.
How can the world allow the US to do this? I mean, come on. It's like everybody knows they're all full of shit. What can we do? I mean, how long can we take this? It's ridiculous. I mean, I'm American, and I think it's full of shit. That's why I'm here. So, like, really, what can we do? Anything? Like, in the foreseeable future? Join the fight. Okay, on that note, I guess we are out of time, actually. But we have a 15-minute break. Actually, if you want to keep talking.
Just, I mean, to respond to what you just said, I mean, we're always talking about that because that's like a big victory, but we had ACTA and we were able to stop that, you know, and it was a group of countries among the richest in the world, the US, the EU and others, who wanted to have their, you know, nice little trade agreement so that they could impose different type of laws to everybody. It was a group of people from governments and their, you know, friends in the industry working on that. Well, you know, citizens were able to stop it. Like I said, it's not like the people in power understood that it was bad to do that, but they understood that they could not do that because people were really, you know, getting very unhappy and not ready to re-elect them. So we have some power, you know, that we can exert, I think.
We just need more of it, I guess.
We need to be numerous, that's the thing. Because that's only when there are a lot of people complaining that they listen to the complainers.
I mean, there was this question, how do we mobilize with around all these very technical, legal, trade expert issues? I think it was the same with ACTA. On ACTA, the group of NGOs and experts was working on the substance and based on leaks and so on, very hard and over a couple of years. And it was really difficult actually to get big attention for this. It was only at the very end when the agreement was finished and ratified by the member states already and in the European Parliament when people actually noticed, and that was based on the previous hard labor all these experts groups did. At that, when it was clear, okay, now it's there, now we actually know what's in the final text and we can clearly say this is evil, this is evil, this is evil, and the Parliament will vote on it in 4 months or so, then people went to the street. And that worked. I mean, that, you know, 20,000 Polish people jumping up and down in the winter, that helped. But you need to do the hard labor, all the analysis and the policy papers and research and so on before to prepare for that final battle.
So if you want to plan the revolution, come up and let's talk, and otherwise you have a 10-minute break and then we start our next discussion. Thank you.